Good evening, everyone. I'm Michael Ettinger of Ettinger Law Firm, and I want to thank you for joining our webinar, 4 Advantages of Using Trusts. The webinar allows you to post your questions. I think if you go down on your screen, you can ask questions, and we are going to hold all the questions till the end. Also, a number of you sent questions in advance. I will answer those as well. I have a printed copy of all of them. So let's get started. Thank you for joining, and I'm very happy to give this seminar entitled 4 Advantages of Using Trusts. A little about Ettinger Law Firm, founded by yours truly in 1991. This is our 36th year. Our practice is limited to elder law, estate planning. I'll explain the difference in a few moments. Here is our staff. That's me up in the center in the middle. My lovely wife and law partner, Suzanne, to my left on your screen. A number of other lawyers, 10 lawyers now, and the rest support staff. Our website, as you can see, is trustlaw, one word, trustlaw.com. And you can find articles on every subject of estate planning. There are hundreds and hundreds of them there, and neatly organized for you. Again, if you just joined and you have questions, just post them and we'll answer all the questions at the end. This is our 36th year, actually, in practice. Our practice is limited to trusts and estates, wills and probate, estate tax savings, Medicaid applications, Medicaid trusts. We have 12 offices around New York State, 2 in Nassau County, Rockville Center, and Lake Success. In Suffolk, 3 offices, Huntington, New York, where I reside, and where I am this evening, town of Huntington. We have offices in Melville and Islandia, Staten Island. We're at 900 South Avenue, in the Cotra buildings there. Westchester, 140 Grand Street, downtown off Coropus. Rockland County, we're in New City on, forget the name of that street, it'll come back to me. Orange County, we're by the police barracks there in Middletown, the Crystal Run. Dutchess County, 2 offices, Rhinebeck and Fishkill, and in Albany right there on Wolf Road. Now, I just want to mention, I've been giving this talk for over 35 years, and I meet people every day. And one of the things I know is that when it comes to elder law estate planning, people are of low confidence. They really don't know what they don't know, and they're desperate for information. We try to present it simple, plain English, and you can find a lot on the website. I've written a book, actually 3 books, but my latest book is Ettinger Law Firm's Guide to Protecting Your Future. You can download that for free on the website. You can watch this video in another form on the website. But our aim really is to increase your confidence, build your confidence, so that you're in a position to make the right decisions, what's best for you. We don't want to tell you what to do. We want to educate you, give you the choices, and then let you decide what you want to do after you're fully informed and you have all your questions answered. So again, it's a confidence building exercise. If you just joined us, if you have any questions, post them. We'll answer them all at the end, including those that were sent in advance. So the topic is elder law estate planning. So the first thing to ask is, what is elder law estate planning? And it breaks down into elder law, which is, you hear a lot about it, but it's actually disability planning. Estate planning in the simplest form is just death planning. Well, we need both, because half of all people eventually become disabled. And of course, the mortality rate is stubbornly stuck at 100%. Here at Ettinger Law Firm, we like to say we use trusts to create order out of chaos. And trusts avoid the pitfalls of wills by saving time and money in settling the estate, avoiding legal guardianship if you become disabled. We're going to expand on these topics. Keeping your assets in the bloodline instead of going to in-laws and their families. And finally, protecting your home and life savings from the very high cost of long-term care. So let's move on to the next slide. So the first of the 4 reasons why trusts protect you better than wills is because trusts avoid guardianship proceedings if you become disabled. Wills don't. So a will takes effect on death, so it's exclusively a plan for what happens after you pass. There's no plan in a will for what happens if you're sick, homebound, or disabled. Eventually happens to about half of all people. Whereas a trust is a plan for all 3 phases of your life. While you're healthy and competent, you can run it yourself. Later on, if you become sick or disabled, you can choose who you want to take over. And finally, just like the executor in a will, you can say who's in charge after you pass, and like the will, who gets your assets and how do they receive them. So let's talk about avoiding guardianship. We mentioned this a few times. About half of all people are going to have a period in their lifetime where they can't handle their affairs. And if you don't have a plan, New York State has written a plan for you. It's called guardianship proceedings. Of course, you've heard of it. I'm going to explain a little bit. But you may think, well, somebody has a power of attorney to handle your legal and financial affairs. Why would you need a legal guardian? Well, the court can override your power of attorney and appoint someone else as the guardian. And this, in my experience, happens most often with people in nursing homes. The nursing home has you in there as a patient or a resident, and the cost is $20,000 a month, and that adds up very quickly. They want to make sure that they're going to get paid, so they'll have their lawyers go to court and say, look, we're running expenses of $20,000 a month. We need guarantee of payment. We want to be appointed legal guardian so that we can control the payment of our bills. And the courts are naturally very sympathetic to that because the nursing home has all the responsibility without any guarantee of payment. So they'll often appoint someone, an attorney for the nursing home, as a legal guardian. The point is, the court chooses who the legal guardian will be, and it may and often is a stranger. Now, you might think, well, my sons and daughters are competent. Why wouldn't they pick them? There's a lot of reasons why they won't pick them. Some of the judges feel your son and daughter or daughter has a conflict. What's the conflict? Well, they feel if they spend it on you, it's coming out of their inheritance. There may be sibling rivalry. Maybe more than one of them wants to be the guardian, and the judge says, well, you can't agree, so none of you. The judge may feel they're not capable, they don't have the knowledge, experience to be a legal guardian. There are many reasons why your sons and daughters might not be appointed. They might live out of the jurisdiction, not subject to the court's authority, etc. So one of the dangers of a guardianship proceeding is once you get in, it's very, very hard to get out. So you want to avoid getting in. And to get out, you'd have to have a court order, and those court orders are rare indeed, because almost always for an older person, it's a one-way ticket. Not only that, but these proceedings are expensive, time-consuming, months sometimes, and stressful. Stressful because you don't know who's going to be appointed, you don't know how much it's going to cost, and you certainly don't know what's going to happen after the appointment. Nobody wants to be in a situation like this. I often say estate planning is all about control. In fact, if I had to explain all of estate planning in one word, I would say the word is control. You're taking back control from the courts and government, giving it back to you and your family. But what happens if somebody has to go into a nursing home and they have, let's pick a number. Let's say they have $500,000. Now, we know under the law, as elder law attorneys, if a client comes to us and says, my mom or dad is going to nursing home tomorrow and they have $500,000, We can generally save about half of that money, 250,000, by moving it over to the children, so long as we spend the other half to pay for mom and dad's care. There's a name for this technique. It's actually called half a loaf planning. What's that expression? Half a loaf is what? Better than none. I can always save half even on the nursing home doorstep by moving it to the client's children. But what if a legal guardian is appointed? Now the person that's going to nursing home, do you think the legal guardian can take 250,000, give it to the children? Of course not, because the legal guardian can only spend the money on the person they're guardian for. Their only option is to spend the whole 500,000 on mom or dad. Now, it's true, the legal guardian can go to court and ask the judge for permission to protect the assets by transferring to the children. I had a case like this years ago. First of all, the legal guardian sometimes won't go to court because it's not their money. They don't care about it that much. But a number of years ago, I convinced the legal guardian to make an application to the judge to protect half the family's assets under the Medicaid law. And to my surprise, the judge turned down the application because the judge said, well, it's mom's money, and I feel it should be spent on her care, and if there's anything left, that goes to the children. In other words, we got the judge's values, the judge's decision, instead of what the family wanted, and that was because we didn't have control. So it was somebody else's choice, somebody else's values being imposed on our client's family. Clearly, it's not a place anybody wants to be because conflicts will often arise between what the family wants and what the guardian wants. So the key is to avoid guardianship, and a trust avoids guardianship. Now remember, power of attorney does not avoid guardianship because the judge has the power to cancel your power of attorney. Luckily for us, the judge has no power to cancel a trust. So trust avoids guardianship. Now, unlike a will, the trust takes effect while you're living, which is why they call it a living trust, and it stays in effect if you become disabled. So the trust is in your name, and you appoint yourself the trustee or manager of the trust. Remember, this is the revocable living trust we're talking about now. And you retitle the assets from your name to the name of your trust. So you're Mary Jones. We transfer the deed to your property from Mary Jones to Mary Jones, trustee to Mary Jones Living Trust, dated whatever the date of the trust is. We show you how to change the name of your investments. We actually do it for you at Ettinger Law Firm. We give you the paperwork to take to the bank. And hence, all your assets in the name of Mary Jones, trustee to Mary Jones Living Trust. And now you buy and sell the same as before. There's no limitations. You file the same income tax return as before. All the assets in the trust use your social security number. In every way, it's the same as you. It's just a plan for what happens when you die or if you become disabled. Right now, we're talking about disability. So what happens? In the trust, you name a backup trustee if you become disabled. Now, what triggers the power of the backup trustee? They have to get a letter from your treating physician saying mom or dad is unable to handle their legal and financial affairs. With that letter, we prepare a document saying mom or dad is no longer the trustee due to disability. In the trust, so-and-so, his name is the backup trustee, his son Johnny, and here's an acceptance. Johnny has accepted to be the trustee, and then they change the name on all the assets to Johnny, trustee of the Mary Jones Living Trust. He runs the trust for benefit of mom, takes care of mom, and then after she's gone, he follows her instructions how she wants the trust assets distributed. But here, the person you know and trust is in control instead of a legal guardian. And it could be more than one person. Generally, let's say you pick two people, we almost always say either of them can act because it's more practical, and it's hard to open a bank account. In fact, impossible to open a bank account where they have to act together because banks don't allow accounts that require two signatures. So almost always, unless it's only real estate, you want to say, if you have more than one person, either of them can act on behalf of the trust. By law, they're required to keep the other trustee informed, but they don't have to get them to sign off. So now you take back control whenever you recover. You don't have to ask a judge for permission. The court can override the trust, guarantees you get the people you choose in the event of disability. Now let's go back into the real world. So Now, unfortunately, you're disabled and you have to go into a nursing facility. What happens then? Well, there's no legal guardian. Your sons or daughters, you appointed the backup trustees, are going to come and see us here at Ettinger, and they're going to say, mom or dad is in this situation. And we'll lay out the various options. Well, you can do this, this, and this. They have the Ettinger power of attorney, which is prescription strength. I'll get to in a moment, has every power known to mankind. Anything that could possibly need to be done, they have the power to do. And we'll do the best to take care of mom or dad and protect as many assets as we can without in any way jeopardizing their well-being. It's a good situation. Ettinger Law Firm has filed over 6,000 Medicaid applications. We have tremendous experience in the Medicaid system and obtaining Medicaid benefits either for home care, called community care, or facility care, nursing home care, called institutionalized care. Been doing it for more than 35 years. Now, I mentioned the power of attorney. Not all powers of attorney are created equal. And in fact, very few of them are elder law powers of attorney, which are prescription strength. Now, as you get older, you need this elder law power of attorney because it works just like medicine. What if you have over-the-counter medicine, but you need prescription strength? Well, you know what happens? It doesn't work. It's not strong enough. So this elder law power of attorney is prescription strength. It has every possible power that we might need if our client becomes disabled. And you only get that from an elder law firm because general lawyers and other lawyers don't know what powers you need if you become disabled because they don't practice in elder law. So the number one thing about this elder law power of attorney is we use it to transfer and protect assets in the event of disability. Now, you might recall a few minutes ago, I mentioned that case about 500,000, you're on the nursing home doorstep. We can save at least half by moving 250,000 to the kids. Well, if you have the standard form power of attorney, you can't move that 250,000 because the standard form allows you to move 5,000 a year. Ouch. Well, in 3 years, you paid the nursing home the 500,000 and you save 15,000, 5,000 a year. That's not very good because under Medicaid, it's move it or lose it. If you can't move it, it's going to go towards your care. So the key to this elder law power of attorney, and all elder law attorneys use some form of this, is the unlimited gifting power. You want to choose somebody in your family to move any amount of assets, hundreds of thousands or more, to protect them if you need long-term care, because you can't move it, you just keep paying and paying and paying until your money runs out. So we have the unlimited gifting power. And of course, if you have a spouse, only your spouse could use it. And then if you have children, you'll make it available to them if they need it, but you won't give it to them unless and until they do need it. And most people have at least one, and sometimes a few people that they're comfortable giving this power to. And if not, the law firm can do it for you. Let's go back for a moment here. Okay, so before we leave reason one, trusts protect you from guardianship proceedings if you become disabled, wills don't. We like trusts to avoid guardianship, keep control in the family. You have your own lawyers to talk to. You can do whatever you want. You don't have to ask a judge for permission. There's no constraints on you. And it happens quickly and efficiently without any court intervention. And you get the maximum protection that the law allows. So clearly a much better situation. The second reason why we like trusts over wills is trusts protect you from probate court proceedings. Wills don't. Not everybody understands that every will has to go to probate. I take it back. Every will that has probatable assets that need to go through probate, has to be proved to be a valid will. Probate is from the Latin meaning to prove the will. So even though you have a will, and it's witnessed, and it's supervised by a lawyer, and notarized, and the whole 9 yards, that will has no effect unless the judge has determined the will was validly executed. And to do that, the lawyer has to prepare a petition. And in the petition, you have to allege that at the time of signing that will, you are of sound mind, memory, and understanding. You are not under any fraud or undue influence, a number of other proofs. We have to serve that on all the heirs and potential heirs, get proof of service back to the court, and wait for the court to rule. The court has absolute control over the estate. This is the probate estate. What's probatable? Assets that were in the deceased person's name alone, like real estate, bank accounts that weren't joint or no beneficiary, any assets that did not have a joint owner, a beneficiary, or weren't in a trust. The sad part about these wills is the executor is frozen, can't do anything until he's approved by the judge. He might be named the executor in the will, but until he has a court approval, which is a document called letters testamentary, it has a raised seal, kind of like a death certificate, and it says this will has been approved, and the court has authorized the executor to act on behalf of the state. And here's the document, the raised seal from the court approving the executor to act. And until the executor has those letters testamentary with the raised seal, he or she cannot do anything. This can cause lengthy delays in getting access to money and other assets. Meantime, bills can't be paid, assets can't be rearranged. It could be a bad market. You may want to buy, sell, trade. Can't do any of that. Can't list a house or apartment for sale. Can't pay bills. Not a good situation. So we've seen this many times. It's unfortunate, but it still happens, although due to the efforts of Ettinger Law Firm, because we pioneered the use of living trusts in New York back in late 1990, early 91. When I started doing it, I was the first in New York, and we started turning all this around so that control is in the family and not in the courts. And I'll tell you how that happened. I was a litigation attorney for 11 years, from 1980 to 1991. And when I heard in late 1990 that if you set up a trust, it was news, it was brand new. If you set up a trust, you didn't have to go to court to settle. I looked into it. I went down to Florida, got trained with, at the time, some of the best estate planning lawyers in the country. You can probably imagine why they were in Florida, all the estate planning lawyers. And I came back to New York. I closed my litigation practice. I formed Ettinger Law Firm to keep people just like you out of that probate court. And here's why I don't like to go to that probate court, because when you go to court, who's in charge? Well, the judge, right? Now, does the judge always act in your best interest? No, of course not. Does the judge ever make a mistake? Well, I used to say, of course, every time I lost a case, the judge made a mistake. And when the judge says jump, your answer has to be what? And when I give public seminars, people would say, how high? I'd say, well, not exactly. It's how high, Your Honor. So who wants to be there having somebody else control your family's assets? This is costly. You pay a pretty penny for this privilege. I would say on average 2 to 3% of an estate. It's time consuming and stressful. It's time consuming because the courts are very slow. Some of them are really slow, like the Bronx and Queens are really slow. It's time consuming because most lawyers charge by the hour. Not Ettinger Law Firm. Ettinger Law Firm for 35 years only charges flat fees. And you'll see why. Because these lawyers, they charge by the hour. What do you think their incentive is if you charge by the hour? Well, to go as slow as you can and put in as many hours as you can, of course, which they do. Our incentive, because we charge a flat fee, is exactly the opposite. Our incentive is go as fast as we can because we get paid the same if it takes a long time or a short time. So we make sure it takes a short time. And also, the nice thing about the flat fee is people know how much it'll cost. As opposed to the hourly, the lawyer says, my fee is $475 an hour. And when I'm done, I'll tell you how many hours it was. How comfortable do you feel with that? Not very. It's like writing somebody a blank check. So people prefer the fixed fee. This is stressful, very stressful, because we don't know how long it's going to take, how much it's going to cost, or what hoops the court is going to make us go through. I had a court back a number of years ago in Richmond County. They made me prove that somebody who was 120, would have been 125 years old, was no longer living. Even though the longest living human in history was 122 years, I had to prove to the judge a 125-year-old was not living. So there you go. If you just joined us, please note you can ask your questions, you can type them in, and I'll take all the questions at the end, including the ones that were sent in ahead of time. Moreover, wills are public records. So anyone can go down and see how much you had, who you left it to, who you left out. This is not what people want today. People today want privacy, and this is where the trust comes in. So the trust avoids probate proceedings entirely for trust assets. Well, that's what we want, because if we avoid probate court proceedings, we have control in the family. So it saves time. Well, we settle these trusts in weeks or months instead of what's often used to be years. Legal fees are generally a fraction, 1/3 or so of the cost of going to court, and you don't have any court filing fees or anything of that nature. But notice, it avoids probate court proceedings entirely for trust assets, which means these trusts have to be funded. You have to get the assets in the trust. And one of the things I'm proud of at Ettinger Law Firm is we do it for you. A lot of firms say, here's the trust, now go and put your assets in it. Well, good luck. People are going to get confused, they'll forget, other things will intervene. We know from experience that clients just don't have the knowledge, the expertise to get it done. We do it for you. And I'm very happy that we do, because this means we know that our trusts are going to work. And that's the idea. No use setting it up and it doesn't work because you didn't put the assets in. So it's a practical matter. You're looking for a law firm that will do this for you. But there's the word control. It avoids court control of your estate, which nobody wants. Upon death, the backup trustee can act immediately without the need for a court appointment. Well, immediately, there might be a couple of weeks, because they have to wait till they get the death certificate to show that you're no longer the trustee. And we prepare a document saying you're deceased. Here's the death certificate, and they have to sign an acceptance of trustee. And then we help them retitle the assets into their name as trustee, so they can give directions, follow the terms of the trust, distribute to the heirs, or hold back whatever you decided you want them to hold back, and for whatever purpose. But it's great. For those of you who've had experience with trusts, you know this. They go very well. Nice thing about trusts, they're private. Only the named heirs can see it. So if you're leaving somebody out, or you're leaving them less than they think they're entitled to, they have no way to do anything about it. Much harder to contest. Wills are easy to contest, because when a will goes to court, the court sends a notice to everybody who's involved, even people who are left out, saying, here's the will, you were left out. Do you accept the will, or do you want to challenge it? Well, if you're left out, a lot of people will challenge. With trust, it doesn't go to court. So if you left them out, they don't know how much you had, who you left it to. They don't get any notice, and they don't have an opportunity to contest. So if you're leaving somebody out, or you're leaving them less than they think they're entitled to, use a trust, and you'll avoid the notorious will contest. A word about the multiple probate problem. This occurs when people own property in more than one state. So you have a place here and one of these pastel colored condos down south. We have to probate in New York and North Carolina, Florida, wherever it is. Fortunately, when you deed your property into your New York trust, we can also deed property from any of the other 49 states into the trust. Ettinger Law Firm does this for you. So you avoid what's called the multiple probate problem. So we like trust to avoid probate, save time and money and heartache and stress, and you have control. You can act immediately, and you avoid the probate in the other state as well. Reason number 3, trusts protect the inheritance you leave if your children get divorced or sued, and keep your assets in the bloodline for your grandchildren. Wills don't do this. Now, this is extremely popular. Here at Ettinger Law Firm, we have done tens of thousands of this type of trust. I invented this trust myself in 2008, and I call it the Inheritance Protection Trust, and it works this way. Instead of leaving it to your son or daughter, we set up a trust for them. Why? Well, we'll see in a moment. Or let me see where these slides, I have to go back because I'm not sure which the next slide is, so I'm going to just leave it this one and expound on it. We want to leave it to the trust for a son or daughter instead of directly, because when you leave it to your son or daughter directly, so you leave 500,000 to your son, or let's say your daughter, I'm going to use your daughter. You leave 500,000 to your daughter, and unfortunately she dies before her husband. Generally, the money goes to her husband. Can he get remarried and share your 500,000 with a complete stranger? Well, he will. People live a lot longer than they used to. So this is a problem. People don't want it to go to in-laws in their families. They want it to stay in their family. So they leave it to an inheritance protection trust, and let's look at how it works, okay? So you name your son or daughter the trustee of their trust. So we'll say Bobby is your son. He's the trustee of the trust. And of course, this is after you're gone, right? Everything, this trust we create now, but it's a standby trust, standing by till you're gone. Now, his half of the estate, we'll say, goes to his trust. He's in charge. He can do whatever he wants. He could buy, sell, trade, spend. So you're not ruling from the grave. But this trust protects him if he gets divorced. What's the divorce rate? Maybe half? That's a good thing. Protected from divorce. It's protected if he gets sued. Everybody gets sued today for something. And then the main reason, this assets, if he dies, it doesn't go to his wife and her family, it goes to his children. So it protects assets going to in-laws and their families. Almost everybody does this today who has assets. You know, generally my rule of thumb is the gift is 500,000 or more. You're going to want that asset protection trust. Everybody virtually wants this because, you know, kind of follows the laws of nature, doesn't it? But if it happens to my son or daughter, I want it to go to my grandchildren. Now, a lot of people think they already have this. They say, oh, yeah, I have that already. My will says if my son or daughter dies, it goes to their kids. That isn't what I'm talking about. That will says if your son or daughter dies before you, the key words are before you, then what they would have gotten goes to their kids. But most sons and daughters don't die before you. They survive you. So if they survive you and they get the money, your estate is closed. The will is finished. It paid out. They got it. There's no protection for what happens if they die after you because it's their money now. Unless you put in a trust. And if you put in a trust, it's actually still your money until they spend it. And while it's your money in that trust, you can say, when they die, it's my trust. I want it to go to their kids, my grandchildren. You know, you can also get protection from your beneficiaries themselves by having somebody else as a trustee or a co-trustee. Now, so many people have children who can't handle money. They're spendthrifts, or they're have substance abuse problems, alcohol or drugs. They could have learning disabilities. They could be special needs. They could have a spouse that bosses them. I see a lot of this. And my client, or you out there listening, the spouse bosses them. You don't want the spouse. You don't want the spouse to control your money. You want your money to be controlled by your family. So you put in somebody else as the trustee. These options are unlimited. But I'm going to write some of you know I write a newspaper column. I've been writing for 13 newspapers for the last 4 years, a weekly column. And I'm going to write a column soon about why you should use an estate planning lawyer instead of AI, artificial intelligence, because so much of this is wisdom and experience, and it's just not available through artificial intelligence. For those of you who have experience with artificial intelligence, you know why it's called artificial. It's not real intelligence. It doesn't have wisdom. It doesn't have experience. It doesn't have feeling. And I like to say estate planning is a social effort. It's a social matter. The legal is secondary to the social. The legal has to serve the social, but here at Ettinger Law Firm, we do the social work first. We get to know your family dynamic, who gets along with who doesn't, why. What about your son-in-laws, daughter-in-laws? I ask them, do you like them? You don't like them? People go, well, why do you want to know? I said, because it affects the estate plan. I have to know what the family dynamic is. And then we can share with you what hundreds and often thousands of other people have done in the same circumstances, why they do it, the different options. It just doesn't exist in the world, and it never will exist in the world of artificial intelligence. So, a little more. So now here we have our family. For me, I have my picture in the way here. But there's grandma and grandpa and mom and dad and the three children, and that's Bobby and that's Mary, we'll call her. Okay, so Bobby dies. Um, it's going to go to his children. Um, if he doesn't have children, it would go back to his brothers and sisters and nieces and nephews because it's by blood, right? But some people are very afraid, very fond of their son-in-law and daughter-in-law, and they don't want to leave them out. So you have an option here. I have to say, most people don't choose this option, but some people do. So you could say, if Bobby dies and he's still married to Mary and they're cohabitating, living together as husband and wife, give half to my lovely grandkids, there they are, the three of them now. Keep the other half in trust for Mary, give her income for life, and on her death, give the second half to grandchildren. So even if she got remarried, husband number two wouldn't get any of the assets because they're in trust. And who's the trustee of the trust? Bobby's brothers and sisters. The aunts and uncles of these kids are the trustees, or the law firm if he's his only child. So that the control stays in the family or with the lawyers for the family to make sure it actually gets to the grandkids when the second spouse dies. The fact is, with this inheritance protection trust, your careful planning continues for decades after you're gone, protects the assets the children get divorced or sued, passed by blood instead of by marriage. And most people want that. And then the fourth reason why trusts are preferred over wills, trusts protect your home and life savings from long-term care costs. Wills do not do this. So this is the famous Medicaid Asset Protection Trust. Again, if you joined us late, you have questions, you can type them in. I'll take all the questions at the end, including the ones that were sent in ahead of time. So how do you protect your assets from the cost of long-term care, averaging $20,000 a month or more in some parts of the state? Well, you place your home and assets into the Medicaid Asset Protection Trust and qualify you for Medicaid benefits. Now, when it comes to the Medicaid Asset Protection Trust, there's more misinformation than information. Clearly, in my experience, people come in very, well, nobody actually, frankly, comes in with the right information because it has to be with an experienced elder law firm. There are not many of them. And of the ones that claim they practice elder law, not all of them have experience with Medicaid. They don't know how Medicaid works. So I'm very pleased that we have 6,000 Medicaid applications under our belt, so we know what works and what doesn't work. So when you get an Ettinger trust, you can be sure it's going to work. It's been approved thousands of times. So you place your home and certain assets into the MEPT to qualify for Medicaid benefits. Let's take a deeper dive. The trust sets up three roadblocks that Medicaid cannot break through. It's an irrevocable trust. Now, very few people know that in New York you can revoke an irrevocable trust. Well, you can't revoke it yourself. So law says, so far as you're concerned, that's an irrevocable trust. But we have another rule that says that if everybody named in the trust, you and your adult children all agree in writing you no longer want the trust, you may revoke it on the written consent of all the named parties. And if one of them won't sign, not a problem. I have a workaround. I'm going to talk about that a little later. But you, the people set up, you can always revoke it, which means your lawyer, yours truly, for the moment, I sleep well at night because I know I can undo anything I did. I can fix anything because I know life changes, people's circumstances change. They may want to undo it. Doesn't happen often, but from time to time it does. When would that be? I can give an example. Sometimes a client will come and say, you know what, we're buying into a life care community. It's called the CCRC, Continuing Care Retirement Community. You go in either independent living or assisted living. They have nursing home facilities there, and you buy into the nursing home. You don't need the irrevocable trust. Or somebody says, my son or daughter is putting addition on the house. They promise to take care of me the rest of their lives. I'm moving in. I want to take the money out and pay them or whatever. So it's nice to know you have control. You can undo it. So you name somebody. The key to this trust is you can't be the trustee. So you usually pick one or more of the adult children. Medicaid has no control over them. And you must limit yourself to the income only. That means interest on CDs, dividends on stocks. So let's look at who does this and why they do it. Well, it doesn't affect your lifestyle. You still receive all your income from all sources, your Social Security, your IRA, your pensions, your interest, your dividends. Most people, that's what they're living on. So you just carry on the same as before. We're using it to protect assets and make sense for assets you're not going to spend, like your home. Well, for heaven's sakes, protect your home. That's not going to make a difference if it's in a trust or not. You still have the right to live there. You pay the taxes the same as before. You have all your exemptions. You mow the lawn, same as if you didn't have the trust. But what about investments that you're just taking the income from, or you're not taking the income, you're just reinvesting it? Well, if you're taking the income, the trust gives you the income. If you're reinvesting it, then you don't even need it. And in that case, you're actually safekeeping it for the long-term care industry. Doesn't it make more sense to put it in that trust, protect it for your family, still there if you need it, but somebody else can't come and take it away from you? So as I said, you have the exclusive right to use and enjoy your home. You have control over the trust by retaining the right to change the trustee at any time. You can also, I don't know if it's in the next slide. No, it's not, so I'm going to go back. You retain control, you reserve the right to change the trustees at any time. You also reserve the right to change who you leave it to. So yes, you put an irrevocable trust, but you say, I'm going to keep the right to change the trustee. I'm going to keep the right to change who I leave it to. So far as I know, the Ettinger Trust is the best in the industry because it has not many trusts have these provisions. You can change who's in charge and change who you leave it to, because not all elder law attorneys file Medicaid. In fact, most of them don't, and they don't know that Medicaid allows these provisions, so they don't put them in because they're afraid they're going to jeopardize Medicaid eligibility if they make the trust too liberal. But in fact, Medicaid doesn't care about this. But the reason we want to have the right to change who's in charge and change who we leave it to is because later on, if you decide that you want to undo that trust and one of the kids won't sign, you don't have a problem because I can take them out as trustee. I can take them out as beneficiary. They're no longer a party. I don't need their signature, which means you're in complete control of that Ettinger irrevocable trust. You can undo it anytime. And control is where I want you to be. Control is what everybody wants. And the Medicaid trust, in my view, is like having your cake and eat it too. You gave it away, but you still control it. It's the only type of trust I know where you can do that. It's just a great thing. So at the end of the day, if you need Medicaid for home care, which you prefer a nurse or a nursing home, they can only get the income from the trust. The nest egg is protected for your children. And we're going to look more in depth. The trust can sell the house and buy a condo. Trust can sell the house and invest the money and pay the income. Maybe go into a rental. The fact is that doesn't start to 5 years over again. You like trading your stock portfolio? You put the stock portfolio into the trust. You name your son or daughter as the trustee. They open an account. They actually keep your account, but they retitle it to the trust. And then they can authorize you to trade on the account. It's called a third-party authorization. Or if you work online, they can simply take out a PIN and give you the PIN, and you can log in as them. Now, we know there's a 5-year look back for facility care, and it says possibly a new 2.5-year look back for home care. This possibility is becoming remote. I'm going to have to change the slide because they kept trying for a couple of years, and it never passed, and it didn't pass. It's not the law. And it's not up for discussion that I've seen the last year or this year. So it may be a dead letter. But there's no look back for home care. Terrific. So that means if you need home care, you can transfer your assets in March and apply April 1 for benefits. We do that for you. Now, I said the Medicaid trust is an income-only trust. What if you need $50,000? Or let's up it, let's say $75,000 to take your whole family and your lawyer on a round-the-world cruise. Well, you can't take out the $75,000, but you can make a gift to your children of any amount tax-free, up to 15 million, so any amount tax-free. They can't give it back to you, but they could pay for that cruise around the world. It's their money. They could do whatever they want. So backdoor, if you need principal, you gift it out to your kids, they can spend it on you. Nice to know that IRAs, 401ks, 403b, 457, all these retirement plans deferred to age 73 are exempt from Medicaid, except for the RMDs. What are those? Required minimum distributions. That, comes out as income. That goes towards the cost of your care if you are applying for Medicaid. So we mentioned the 5-year look back for facility care, but it's not an all or nothing rule. Let's say you set up the trust 4 years later, you have to go into a nursing home, you only have to pay for 1 year. You already got 4. In other words, it prorates according to time, so it always pays to get started. If you don't make the 5 years, you only have to pay for the time that's left. So our conclusion kind of ties in with our introduction. I said, here at Ettinger Law Firm, we like to say estate planning with trust creates order out of chaos. And here's what it does. It avoids guardianship on disability, keeps my favorite word, control in the family, and you have your asset protection options with your elder law attorney to protect at least half and sometimes more. It avoids probate on death, keeps control in the family, saves significant time and money in settling the estate, keeps your affairs private. Protects the inheritance you leave if the children get divorced or sued, then passes by blood to your grandchildren instead of to in-laws and their families. And finally, protects your home and life savings from long-term care costs, make you eligible for Medicaid for home care or nursing home care when you need it, and Ettinger Law Firm will make that application for you. So now let's talk a moment about the law firm's unique planning process. This is my new book, 2026 edition, Ettinger Law Firm's Guide to Protecting Your Future, my 3rd book. And it's plain English. It's 300 plus pages, but you don't have to read everything. When you come in and we have a consultation, I'll tell you which chapters apply to you. Might be an hour or an hour and a half of reading. But our process has begun with this seminar. This is a very good warm-up, I believe. We're going to invite you for a no-cost initial consultation. At the initial consultation, so you come in, it's very low-key, it's very sociable, I would say, because we really want to see who you are and get to know you a little bit and see how your family dynamic is and what your personality is like, what suits you, what doesn't suit you. The first thing we're doing is trying to get people to relax, be comfortable, not to be intimidated, not to be afraid, not to be worried, not to be anxious. We're anti-anxiety, anti-worry. In fact, on my desk, I keep a stone. If you can see this, let me get that. Get that right there. It says no worries. It's right in front of our clients when they come in. And we're all about no worries. Our job, we believe, is to eliminate your fear, worry, anxiety. That's why we're here. I like to say sometimes we're in the peace of mind business. We want our clients to have peace of mind. That's why they're coming to us, and we do everything we can to give it to you. So the first, we're going to review your existing plan if you have one. Almost always it's inadequate, frankly, because it's a will when you need a trust. Wasn't done by an elder law firm. The power of attorney is inadequate. We frankly never see a plan that is going to be as good as the one that the client is going to leave with, because if they had a plan that good, they probably wouldn't be in front of us. But we rarely see it, even from other law firms. We rarely see a completely funded, properly done estate plan. It's a hard commodity to come about these days, unfortunately. But we're going to review the plan. And we'll tell you what the drawbacks are, and we'll explain it to you, and people understand it very, very quickly, because it's common sense when we explain it. Well, this is what will happen here, this is what will happen here, this is what's missing here, this is what's missing there, these are the issues you have. And people appreciate the time that we take to explain things. We're going to give you a free copy of the book, tell you which chapters apply to you. It's available for free as a download on my website, trustlaw.com, but not everybody wants to download 300 pages. So I'll come into the office, we'll give you a copy. Well, generally, in most cases, when you come in for the first meeting, we're going to tell you, based on what we think you need, how much it will cost, because people like to know. At the end of the first meeting, we've covered a lot of the bases. We've suggested what the plan should be, how much it'll cost. We give you the book, read this. And now we set up a second consultation, also no cost, to have your questions answered. So now you come in for your second meeting, generally a couple of weeks later. We answer any questions you have from the first meeting, or anything you looked into, or the chapters you read, or the video you watched on my website. And now we draft the estate plan together with you. What does that mean? Well, we get your input into who do you want to make medical decisions? Who's your first choice, second choice? Who do you want to put in charge of the estate? One person, more than one person? How do you want it paid out? All at once, over time? Do you need special provisions for certain people? Who's going to be the trustee if you're going to hold it back? What's the plan of distribution and why? And you'll get a lot of input from myself and the other lawyers here at Ettinger Law Firm. We'll give you suggestions. We'll tell you what other people do, why they do it, and we'll put you in a position to make the best choice for yourself. At the second meeting, you'll get a detailed written proposal. The fees will be the same generally that we mentioned the first time, unless something was not disclosed or overlooked or misunderstood, but almost always it's the same. But now it's in writing, the fees. We say, what do you like to do? If people decide to go forward, they don't pay us. We don't take fees at this meeting. Even if they decide to go forward, we don't take a retainer. We invented this, well, more than 10 years ago. I believe we're the only firm in the country that doesn't take a retainer, because all estate planning lawyers are trained the same way. I was trained, well, if the client wants to go ahead, they sign the agreement and they give you a check for half the fee. And I did that for, at least 15 years until I questioned it myself. And I said, gee, the way I was trained is not the best way to do it. And here's why. It dawned on me one day. I was giving seminars. I've given in my time over 5,000 seminars. And I would always talk about control and taking back control and how important control was. And one day it dawned on me, the way I was trained, when you ask the client for the retainer, you're actually taking away control from them. Why? Because when you give the lawyer the check for half the fee, what do you have? You have nothing. You have a promise. In fact, you have a loss of control. You have a promise from the lawyer, and you have to hope the lawyer will perform and will perform to your satisfaction. So now you've lost control. So I realize it doesn't make sense for me to talk for an hour about taking back control. And the first thing that happens, you come to my office, is I take control away. So I said, this is not right. I create a new kind of agreement that only Ettinger Law Firm sign. You don't sign it, so you're not bound to it. And my agreement says, we're going to do all this work. Here's the list. This is how much it'll cost. But no fees are due until after the documents are signed. And my agreement says, unless and until you write us a check at the end, you're not bound to a law firm. You're free to walk away, which means what? You're in control. Well, if you're in control, clearly that's the best place for you to be. And we feel if we're here to serve you, and that's the best place for you to be, it must be the best place for us to be. So we, not only do we do it, and not only are we the only firm, but we love it because our clients are happy, we're happy. In fact, we only have happy clients because nobody pays us unless they're satisfied. What does that mean? We make sure they're satisfied. That's what it means. We cross the T's, we dot the I's, we fund the trust, we're there for you. So it's been a tremendous breakthrough, and it's too bad other lawyers don't know about it or appreciate it. They even have trouble understanding it, but we like it and our clients like it. So now you come into your third meeting, we review and sign the documents, uh, and you pay at the end. It could be a credit card, but these days we charge 3% because that's what they charge us, and nobody wants to pay that. So people usually pay us by check, and you can pay all at once, or you could pay it over 3 months. Some people like to pay it out of their cash flow or for other reasons. It doesn't make a difference to us either, is fine. Now, let's go back. So the standard in New York is thank you very much. In fact, the bar is, I was listening to a CLE a few years ago, a panel of quote experts, ethics counsel, other law counsel, defense counsel. They actually advised lawyers in New York that after you sign your trust, we should send you a letter saying, thank you very much for your patronage. This concludes our representation of you in this matter. So, and they tell us to do this because it starts the statute of limitations running from the time of the letter. So if you made a mistake after a few years, the client can sue you. Isn't that wonderful? Well, what about the client? I know it's good for the lawyer, but what about the client? So I say, and this is the way lawyers are trained, which I don't want to do a seminar on how lawyers are trained, but I'm not happy with some of the ways that lawyers are trained. And one of them is they're very risk averse. So the lawyers are actually more concerned with the 1 in 10,000 clients that are going to sue them than the 9,999 that aren't going to sue them. So we, of course, do just the opposite. We don't say goodbye. We say thank you, welcome to the firm. I'm not worried about the client who's going to sue me. I'm assured for that anyway. But I'm concerned about the 9,999 that aren't going to sue us. So we say, you're now a client to the firm. We're going to keep you up to date of law changes and matters through our weekly Ettinger Elder alert. That's because it comes by email, so we call it the alert. It's a little play on words, but I've been publishing that for years and years, once a week, and it's a very popular feature, and you don't have to worry you're going to miss anything. Every 3 years, we call you in for a free review. We want to see if there's any change to your health, your assets, or families. So we don't charge for this. We take responsibility for it, just like we take responsibility for funding the trust. And we do this because we don't charge for phone calls, emails, or questions. We want you to communicate with us. I must tell people 5 times a day, I'm telling people, please call. It's no bother. It's no bother. Please call us, email. Have your questions answered. Why? Because we're anti-stress, we're anti-anxiety, we're anti-fear, and we're anti-worry. We're against all those things. And how do you help people? As soon as they have a worry or concern, call us. We'll take care of it. Call us, please. Email us. You're going to get an answer right away. Anything that's bothering you, our job is to make sure it's not bothering you anymore. And that's quite successful. But the point is, by using this program, your plan is never more than 3 years old, is designed to work when you need it. Not when you signed it, could have been 20 or more years ago. So this has been very effective. We have saved thousands and thousands of people, tens of thousands of problems because we catch things and we make sure that plan is never more than 3 years old. It's always current. Okay. This is actually one of the reasons why so many people choose Ettinger Law Firm, because we maintain the thing and we also have a succession plan. You know, we're not 1 or 2 lawyers here. We have a succession plan so the firm will go, past the founder's lifetimes. It'll be there decades from now and hopefully 100 years from now so that your family can use it too. We're already on our 3rd generation planning, and we'd like to be there for 6 and 7 and 10 generations. But we have a plan for that to happen. You don't have to worry that your law firm is not going to be there. So now let's talk about the consultation. Very simple. It'll be with myself, my beautiful wife and law partner, Suzanne Ettinger, who's very highly thought of, a wonderful person. You'll be very fortunate to meet with her. When people do, I tell them they got the upgrade. So they'll meet with myself or Suzanne generally here on the island. I go to White Plains from time to time. I go to Staten Island from time to time. And we have excellent lawyers in White Plains, in New City. All our lawyers are experienced, have been with me for many years. Everybody's trained the same. Everybody does things the same. We're constantly in communication with each other. You're going to get the same plan no matter who you see or where you go. Um, these can be in office, by video, by phone. You know, in office always better because there's nothing like a in-person meeting, to establish rapport. But not everybody can make it, so you can do a Zoom. You can even do it by phone. We're very accommodating and we're very flexible. And if you need to reschedule, we're fine with that. We understand things happen. Just call our 800 number or visit us at trustlaw.com. You can book it right on the website. And now I'm going to, first of all, thank you for listening. That was quite a bit. And let's see if we can go into, see if we have any questions from the group here. Let's look at that. Okay, stop sharing. Okay, let's do that. And questions. We have a few. Let's see. Okay, more. Here we go. Okay, Ruth. I'm just going to mention the first name for privacy. Ruth says, if you have a Medicaid asset protection trust, how do you qualify for free home care if your monthly income is too high? I love that question, Ruth, because I get this question all the time. People think their income is too high for home care. It's rarely too high, rarely too high. I'm sorry. Linda, if you have a question, just type it, okay? Um, because the income can be sheltered with something called the pooled income trust. It's on my website. You can look under practice areas and look at the applying for home care with the pooled income trust. But what happens is all the income that you need for your care, for you to be able to afford to live in your home, you're allowed to keep. You pass it through what's called the pooled income trust. It's too lengthy to explain it here, but there's no such thing as your income being too high. You can shelter all the income you need to live on, and if there's excess income, yes, that'll go towards your care. But you'll be able to afford your own home. There's an allowance. All your expenses are paid out of your income. There's an allowance on top of that. There's no such thing as the income being too high. You come and see us. We'll go through all the numbers with you and show you how to qualify. Ruth says, if you have an irrevocable trust, you still need a will. Yes. Another good question, Ruth. With a trust, you get something called a pour-over will, P-O-U-R. And this does two things. The pour-over will, by law, a later will cancels an earlier will. So it voids your old will. You can forget about it. It has no effect. And this irrevocable trust, now the new will, the pour-over will, says I leave everything to my trust because my wishes are written in the trust. But at Ettinger, we make sure that you don't have to use that will because it's not in the trust. We're going to make sure it has a beneficiary as a joint owner so that there's no probate for the non-trust assets. However, mistakes happen. The client doesn't tell us about something, forgot about something. It's there just in case. Ruth, I explained this was at 6:30. I explained the difference between a regular power of attorney and the elder law power of attorney. The elder law power of attorney is prescription strength. And William says, does a trust make a will unnecessary? As I said, William, we revoke your old will and we leave a pour over just in case we need it. Anonymous. What is the advantage of trust compared to transfer on death? Well, the advantage of a trust, there are numerous advantages. The main one is the trust will protect your assets in long-term care. A transfer on death is not going to do that because by that time the asset might have been spent on your care. But if you have any type of specialized distribution, or you need control over the assets after you're gone, such as payout over time or special needs, then TOD won't do that. Anonymous, if you have power of attorney, does still hold after the death of the person and avoid probate? No. By law, all powers of attorney are automatically cease at death. They can't be used to avoid probate. William, what is the scenario where a trust would not be necessary? Well, a young couple, we don't do trust because generally they don't have much assets. They have both names on everything. And they have a will just in case they both die in a common accident, which is very rare. It keeps their costs down until they're older and they need more sophisticated planning. Their kids are not old enough to be married, have grandkids, so they don't need to keep it in the blood. So I'd say, people generally up to in the up to the 50s, you can get by with wills. Starting 60s, trusts become more necessary because the risk of disability merits the expense of setting up a trust. Edna, I'm selling my house, which is in my trust. Do I need to open a special bank account to have the proceeds transferred to closing? Well, if it's an irrevocable trust, yes, because the trust assets will be paid to the trust. You go to the bank with the original trust, the receipt we got from the IRS proving that that's a correct tax ID number. Open an account with $100 in the name of the trust, so when you get the proceeds from the sale, you can just deposit. You already have the account open. Anonymous, is Ettinger in New York only? Yes, we're in New York only. If you're looking for Florida, we have good relations with South Florida lawyers. We know for decades. We know lawyers around the country, but if you need a lawyer somewhere else, email me, mettinger@trustlaw.com, mettinger@trustlaw.com, and I'll tell you how to get a lawyer somewhere else. Anonymous, is the unlimited gifting power only granted to and allowed to be used by a lawyer? No, the unlimited gifting power is generally you're going to give it to somebody or more than one person in your family that you trust. If you don't have somebody that you trust, will do it for you, but we're the backup. Anonymous, can you repeat the category of assets that don't have to go through probate? Anonymous, there's only one asset that doesn't have to go through probate, and that's an asset that's in your name alone when you die that does not have a beneficiary and does not have a joint owner. Anything in your name alone when you die has to go through probate because nobody can get access to it until an executor is appointed to step in your shoes and follow the terms of your will. Ruth, what information did you bring to consultation? Ruth, you're asking the best questions. Thank you. You know, we send you a form. When you book the consultation, we'll send you a form. And you, if you like, fill it out. Some people fill it out, some people don't. We make it optional because in this day and age, people value their privacy. We respect that. Of course, it's helpful if we have the information. We can give you better, have the form filled out, I should say. We can give you better advice. But I'm perfectly happy that you came with the form or without the form because I want to meet you first anyway. And you want to meet me first, and you want to, kind of get to feel the situation and feel if you want to disclose this information. And I would say after meeting, almost everybody feels much more comfortable. And I'm happy, because what's my job? Is to relieve stress, worry, anxiety, and fear. So I don't want anybody to come in doing something they don't want to do. So it's optional, but a lot of people fill out the form because they want to get the best advice, but it's optional. Patricia, will you expand what you mean when you say your firm sets up the when I say we set up, we transfer the assets to the revocable trust. So you have a brokerage account, we write to your broker, usually by email, and we give them the paperwork to transfer to the trust. If it's a bank, you have to go in person, but we give you a turnkey. You go to the bank, here's all the papers the bank is going to need. If it's real estate, we prepare and file the new deeds, but we make sure that trust is funded. Susan, does the standby trust have to go to probate? No trusts go through probate. So the Inheritance Protection Trust is a standby trust. It's standing by till a future event, which is the death of yourself, and it gets funded when you die, but there's no probate for that. Boris asks, is it a good idea to transfer a house using transfer on death? What Boris is talking about is the new transfer on death deed, a couple of years old in New York, but it has some drawbacks, actually has many drawbacks, doesn't protect the assets from long-term care. You can have multiple owners if you have too many kids, and they start fighting about whether one wants to sell, the other one doesn't want to sell. There's no boss. They don't agree on the price. They don't agree on when to sell it. All kinds of fights break out. And also, it takes longer to clear title, so you can't sell it as quickly with a TOD as you can with a trust. Chris, can you provide information about practices in Orlando? So, Chris, in Orlando, I hope you have a pen handy. Write this down. Go to the website NAELA. NAELA, which is an acronym for the National Academy of Elder Law Attorneys. So NAELA.org. You go to their website, .org, and you can search for elder law attorneys by zip. So you can take your zip and you can scroll at 5 miles or 10 miles or 25 miles. And This is for everybody who's looking for an out-of-state elder law attorney. I usually tell people to do this. First, look at all their websites, and you can tell a lot from a website, right? I mean, it's your due diligence. And then pick the two from the websites that you think are best and go and meet with two of them. And of the two of them, you're naturally going to like one better. I don't suggest you meet more than two because when you go to more than two, you start to forget who said what and you get all confused. So do it my way, and I think you'll be successful. Anonymous. How old does someone need to be to create this kind of trust? Well, it's not necessarily age. I mean, 60 plus, we're talking, trust for most people. But if you're younger and you have a taxable estate in New York that's over 7.5 million, you need a trust to save estate taxes. If you have property out of state, you need a trust to avoid the multiple probate problem. If you have a special needs child, you need a trust. There's a number of reasons. Madeline, what if you have long-term care insurance? Do you still need the MAPT? Well, Madeline, if you have long-term care insurance, I'm going to determine what's the daily benefit, how much is your income, and is there a significant gap between your income and plus the long-term care insurance and the cost of care? If the gap is not significant, you can make it up with your assets. If it is significant, we'll discuss whether or not we should have the MAPT. Govind, I moved to Florida from New York and have irrevocable trust. Can you help me review it and do the needful changes or establish a new trust? Take it to an elder law attorney. Just like I said before, search by zip at NAELA. I'll repeat it, NAELA.org, and we'll go from there. Santiago raised a hand, but I'm going to ask you to just type the question because I can't answer the raised hand. Next, William, what information did you bring in our first meeting? The form, we send you the form when you book the appointment, so the form will tell you what you need to bring. You fill it out and also tells you what you need to bring. Is there a charge for any updates as a result of the 3-year review? Yes. If an update is changing, not putting assets in or taking them out. An update is changing who's in charge or changing who you leave it to. That doesn't happen very often, but when it does, it's legal work. We get paid for legal work. We don't get paid to review. If we need to make a change, we get paid. That actually helps pay for the 3-year reviews. That's why they're free. They generate enough work to make it worthwhile. Richard and Marion, what do you do for medical advance directives? That is the healthcare proxy and living will. Health proxy names the person you want to handle your medical decisions. If the doctor certifies in your chart, you're unable to make the decisions for yourself. And the living will is the so-called pull the plug. It gives them authority to terminate life support when they feel there's no hope of recovery and no meaningful existence. Arnold says, can there be mullible? I don't know what that means, so you might have to retype that. Anonymous, will you meet with a new client in the Fishkill branch? No, what will happen there is if you do want to meet with me and you're up there, I don't go to Fishkill, it's too far from where I live, although I spent many years there. I built the office, I trained the people. But if you still want to meet with me, schedule a Zoom. We're going to have 1 or 2 Zooms, and then you can sign in the Fishkill office if you prefer. Alice, your session was so informed. Thank you. Thank you, Alice. Have a trust and are interested in creating an MAPT. Do you assist out-of-state clients? Out-of-state, you got to look at the NAELA.org. Joanne, is the irrevocable trust still valid if you move out of New York? Yes, the trust is portable. Good anywhere. Next, Anonymous. What happens if our permanent resident is no longer in New York and our child doesn't live here either? Trust still works. Linda says, how do trusts work if there are no children? Do things get complicated if heirs are not related? Not really, Linda. You're going to pick somebody as your trustee. They'll follow your instructions. You'll give them contact information for your heirs, and they'll carry out your wishes. And if you don't have somebody, the law firm will do it for you. Roseanne, there are no tax advantage to gifting, so why do it? Well, you might do it out of the goodness of your heart, Roseanne. It doesn't have to just be about taxes. But putting that aside, there are tax advantages to gifting, but only if your estate is over 7,350,000. Otherwise, you don't have a taxable estate. Lorraine, can you still sell assets in irrevocable trust? Absolutely. This is one of the misinformations out there. People think it's an irrevocable trust. You can't sell the house. Nonsense. You can sell any assets. The trust sells it. The trust is a person legally. It can buy and sell just like you can. The trust can sell a house and buy a condo. Doesn't start the 5 years over again. Alan, if I set up with you in New York, it's still good. Yes, the trust is portable. You can take it to Florida. Um, Anonymous, do we have to revalue the trust again when the new law is in place, such as if the New York State estate threshold is reduced to 750K? Don't believe everything you read in the newspaper, eh? That'll never happen. They're already bleeding patriots, expatriates in New York. They can't afford to reduce the estate tax. They're losing all the people who have assets and pay taxes. Not going to happen. It's just like a shot across the bow. Anonymous. Uh, I'm asking this because someone asked for lawyers in Florida. Again, uh, if you're on the East Coast, anywhere around Palm Beach Gardens, Delray Beach, Port St. Lucie, go to CARP Law, KARP carplaw.com. Good friends of mine for over 30 years, board certified elder law attorneys in Florida. Anonymous, so I'd like to get an estimate for the fees involved. A lot of people ask about fees. I would say, fees for revocable and irrevocable trusts are generally 6,500 to 8,500, depending single, couple, revocable, irrevocable. A little more if you have over 7.5 million, because you need two trusts to save the estate taxes. And then if you decide to do those inheritance protection trusts, they get charged individually, 1,500, 2,000 for each of the child that you want to do that for. Richard. How do trusts avoid the fiscal cliff problems when assets are over the 7 million-ish? I do a lot of this, Richard. I train my lawyers to do it. There's a lot of ways to do it. If you have a spouse, you can set up two trusts, double the exemption. We can make gifts while you're living and get you under. We can put in the Santa Claus. The Santa Claus says anything that would cause an estate tax to give to charity, so you can't give away more. So anything over the exemption goes to charity and brings you down to the exempt level, no tax. And you pick the charities. Uh, Anonymous, are there additional charges whenever you need advice or changes to your There's no charges for advice. There are changes to, obviously, there's fees to change the documents. I think they're pretty reasonable. Roseanne, as an executor to a friend's estate, how can I protect my assets from creditors of the estate? Well, your assets are not exposed to the creditors of your friend's estate, so you don't have to protect them. Uh, Anonymous, since this session has been recorded, can we review everything addressed again online? You're going to get a copy of the recording so you can watch it again. If you want the short version, if you go onto my website, trustlaw.com, you can watch my video. It's 37 minutes, and it's a short version of this. Lorraine, if you sell a house from an irrevocable trust, who has access to the money? Well, again, the trust sells it. The money's paid to the trust. You can gift it out. Remember, you have an unlimited gifting power. You can gift any amount to your sons or daughters. I can't give it back to you, but they can spend it on you. If you invest it, you get the income. Now, you can keep asking questions, but I'm going to take a quick look at the ones I got that haven't been answered. Okay. Should other assets besides real estate be placed in the trust? Yes, you put in the trust all of your assets except IRAs, 401ks. Those do not go into the trust because that would be a taxable event. Can't put your IRAs into a trust, but they don't need to go into trust. They avoid probate. IRAs and the like are exempt from Medicaid, so we don't have to worry about that. And we do very often leave the IRA or 401k. We name the inheritance protection trust as the beneficiary, so that money stays in the blood. You don't need to change your will every time you move to another state. It's portable. Jim wants to know, how do you avoid the 3-year look back? This has to do with tax law. If you make gifts in New York and you die within 3 years of the gift, it comes back into the estate. There's no way around that. Okay. This client asks, what happens if you have no children or family or close friends to manage your affairs when you're elderly and need help paying bills, running a house, paying taxes, etc.? Well, there's bookkeeping services that'll do this for you, but you have to make sure they're bonded so they don't steal your money. And for medical and the like, I invite you to Google Life Care Manager. Life Care Manager. These are retired nurses who do this sort of thing, and they have a national association, the Life Care Managers Association, and you can look at that, and you can hire one of those people. You can also name the lawyers here at Ettinger Law Firm your backups, so we can do all this for you if something happens. Okay. Um, would a trust help a disabled person with no kids? That's Kevin. You know, that's too much to answer, Kevin. You have to either schedule a Zoom or a phone or come in and see me because we have to ask you too many questions before we can answer that. Um, this fellow says he has property in his name and his wife's name, and he wants to remove the name of his deceased wife, but you don't need to do that because um, automatically you own the property and you'll be able to deed it or sell it in your name alone. You don't have to take her name off the deed. Um, this person says they inherited their mom's home and they want to keep it in the bloodline. Should I put it in your children's name? No, because you lose the stepped up basis. And if you're still with us, Richard and Marianne, just go ahead and type any questions you have. But if you're still with us, I want you to know about the stepped up basis. The stepped up basis, hang on. The stepped up basis means this. When you pass something by inheritance, the basis, which is what you paid for it, gets stepped up from what you paid to date of death. So let's say you bought a house for 500,000, you die, it's worth $1 million. Your heirs get it from the estate as if they paid $1 million. Well, if they paid $1 million and they sell it for $1 million, there's no gain, no capital gains tax. So you want to pass it by inheritance, not give it to them while they're living, because you give it to them, if you give it to them while you're living, it's as if they paid 500,000. They'll pay the capital gains because they didn't get the new basis because they didn't get it by inheritance. Regina says, I'm single, no children, own home, have long-term care insurance. The cost is getting too expensive for me to maintain much longer. And I want to leave the house with my beautiful nieces. I need to protect the house from nursing home. That's easy. You put that into Medicaid Asset Protection Trust. It'll be there for your two beautiful nieces. Okay. John says, if your home's in an irrevocable trust and you sell it to move into senior living, can the proceeds be used to help with expenses? Yes, you can gift out to your son or daughter or any of the beneficiaries. They could pay the fees for you. Now, James says, son has which trust should I use? Revocable, irrevocable, special needs. My son has a disability, but is functioning as an adult. I have no heirs except for him. I'm a widower. I can't decide which way to go. I have two properties. Well, he may or may not need a special needs trust. We need to explore whether he's receiving any government benefits, how functional he is. Can he handle assets if something happened to you? So we have to have an in-person meeting, James, to discuss that. Similarly, Karen says she has two small home mortgages. IRAs have beneficiary. Husband is a New York resident. Wife is a Florida resident. What are options for the trust? Well, this depends on your ages, depends if you have kids, and it depends if you have long-term care insurance. So I have to meet with you to get all those questions answered. How old are you? Do you have children? Do you have long-term care insurance? That's going to impinge on what type of trust you use and why. Here, Ellen has a house with her ex-husband, and he owns half and he doesn't want to sell. In New York, you can actually force somebody to sell. You can bring a partition action and force the sale of jointly owned property. Suzanne says, my accounts are TOD. Why is the trust better? My biggest asset is my appreciated home. Can I put only that in the trust? Yes, of course, you can put only the house in the trust, but if you want to protect the money, you would put in the trust also because TOD just avoids probate, doesn't protect the assets in long-term care. And Maggie, if you're still here, I see her with a home care agency. Good for you. She says, Maggie says, I'm looking to gain inside information to best support our clients when these natural concerns arise. Thank you. I thought that was very nice and admirable of you to want to get this information for the people you serve. Here's somebody who wants to know, George, how to put their LLC into the trust. We have a document called an assignment. We can assign your LLC interest to the trust. Can you add assets or trust in irrevocable trust at any time? Yes, you can. And then it's 5 years on the new money. I want to know more about the caregiver agreement before doing versus a trust. So a caregiver agreement, Donna, protects income. So you can pay the caregiver, a family member, and that will get money out of your estate without jeopardizing Medicaid because the caregiver is allowed to get paid. The trust protects assets. The caregiver agreement protects income. They're actually two different things. Now, let me go back. I have more questions in my hand, but Alan says, thank you, been very helpful. I'll be calling. Thank you, Alan. And Roseanne says, can you please repeat the answer to my question about being the executor of a friend's estate? I didn't hear it very clearly. Okay, well, let's see if we can go back and find it in all these questions. Here you are. Okay, yes, a few questions. I'm not going to spend too long, but okay, what I'm going to do is I'm going to ask you to repeat that question because there's just too many to find. I didn't see it. So write the question down again and I'll answer it again, okay? And let's see here, okay. Yes, okay. Roseanne, repeat your question about the executor and your friend's estate. I'll answer that. Anonymous says, in the bank account, you have to add the children that are in the trust. So when you write a check or pay online credit cards, you need their authorization? No, 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 no. In the bank account, you can make them joint, you can make them beneficiary. Um, if it's in the trust and you're the trustee, then they don't get added on it. You never need their authorization to write a check or pay payments. It just never happens. Anonymous, if a married couple has an irrevocable trust and one of the spouse dies, the other spouse needs to have the trust updated, revised? No. The trust is designed ahead of time to continue for the surviving spouse. Nothing you have to do. Govind, do we pay more taxes at a higher rate in irrevocable trust compared to living trust? No. Our irrevocable trusts are called grantor trusts. They remain yours for tax purposes. They still get taxed to you individually. All the accountants know the term grantor trust is the same as you for tax purposes. Anonymous, if our assets are moved from brokerage account into the trust, is it a taxable event? No, no, no. Nothing's getting sold. It's just getting retitled. And you have the same broker, the same funds. It's just a different name on the account. Okay. Go ahead if you're still there. Roseanne, if you're still, oh, there you are. Roseanne says, as an executor of a friend's estate, how can I protect my assets from creditors of the estate? As executor, your assets are not exposed to the creditors of your friend's estate because the executor is just a manager. They can only go after the assets of the estate. So I don't think you need to be too concerned about that. Penny, if you made an irrevocable trust 8 years ago and put your house in it, now you want to open a bank account. Is the account going to go through the look back? Is the bank account? No, 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 no. I mean, you're only going to open it with $100. It's not going to affect the look back. You're just going to open the bank account. And if the answer is no, I'm not sure actually what you're getting at past that, so I'll leave it. How often should my trust be reviewed? I think once every 3 years, but at least in between if there's major changes in the family or your assets or your health. You don't have to amend the trust each time a beneficiary passes because all the trusts are designed for what happens if a beneficiary passes. It's built in. We know ahead of time what's going to happen. Okay. If you sell the house in the trust, you want to make sure it's done the correct way. Just the real estate lawyer will know how to do it, and we're happy to answer any questions they have. If you have a disabled child, Jennifer, to protect our benefits, you're going to need a special needs trust. We do that. If a property is transferred in name, do I have to pay an inheritance tax to the IRS in New York State? No, we do not have an inheritance tax. I explained the stepped up basis, okay? William, who's actually asked a number of questions, but he also typed one in. I'm 72, my wife is 70. We're interested in learning about trust. I was going to request an in-person meeting, but thought we would start with this webinar. Is this the correct way to start? Really, actually, William, it's the perfect way to start because now you're warmed up a little bit. You'll get more out of the in-person meeting, at least in my view. So with the trust, you get the stepped up basis where it's revocable or irrevocable, doesn't matter. Can a spouse going to a nursing home gift their assets to a spouse to avoid Medicaid? Yes. You gift it to the spouse at home, they do spousal refusal, and then the one going into the nursing facility will get Medicaid. Can the bank call in the mortgage if ownership is changed to trust? No, they cannot. Irrevocable trust and Medicaid trust, Migdalia, the same thing. At what age do we do an irrevocable trust? At Ettinger Law Firm, we feel you can wait till 65, 70, no problem. Closer to 70. Until then, you can get away with a will usually. Unless you have taxable estate, you have property in other states, you have special situations, special needs, etc. I might be getting close to the end of these. Okay, so I'm buying a house in Florida with my boyfriend. He has two sons. I have one daughter. I want to ensure my daughter gets half the house as we're splitting expenses half. How can I protect her interest? That's Celia. Celia, in that case, you would each have a trust. You put your half in a trust, he'd put his half in a trust. Your trust would say he has life rights in your half if he survives you, and then on his death, your half goes to your daughter, and his would say the same thing. If he dies first, you have life rights in his half, and then on your death, his half goes to his kids. Trust will do that. Okay. To be a trustee, our fee is 1% of the first million. This is for Mel, and 75.75, 3/4 of 1%, anything over $1 million. Can the benefactor access the inheritance needed for or a predetermined amount until depleted? Yes, whatever you wish, we can put in. That's within the realm of reason. You have a trust for each child, Frank. There's no difference for capital gains with a trust or individual. Income is passed through to your individual returns. You won't pay the trust tax rate with hard trusts. Is there a trust for excluding children from inheriting? Yes. Trusts are used if you want to exclude children so you don't have a will contest. That was Janine. Patricia, yes. So the see-through trust rules. So if you name a trust beneficiary of your IRA or Roth, you're allowed to do that. They get the 10-year payout. The see-through trust rules means that if you have a trust, the IRS will look through the trust to the oldest beneficiary named in the trust, and they'll do the payout. The 10 years, the first 9 years of the payout will be based on the life expectancy of the oldest trust beneficiary. We talked about how to avoid the New York State cliff, 7.35 million. Can a non-resident be your trustee or executor in New York? Yes. That was Bruce. Barbara says, do you have your own do you use or have a title company review property deeds are correctly filed? Well, we filed the deeds correctly, but we don't guarantee your title because we only take the deed you gave us and we put that in the trust. So you would have title insurance from when you closed on the property, but we don't guarantee title. We're not real estate lawyers. We only take what you have and put in the trust. We don't guarantee the property. So the trust assets are taxed to you individually, whether it's revocable or irrevocable. You can't put an IRA into a trust. That would be a taxable event, but you don't need to put an IRA into a trust because it's exempt from Medicaid and exempt from probate. Okay, and then finally, Pat says, I have questions regarding trusts. I have my IRA and Roth in a revocable trust. That's not possible. They can't be in trust, so something's wrong there because that would be a taxable event. And they said, the beneficiaries of those trusts are 3 trusts in each of my children's names. So I'd like to see those. When they inherit, will they have the 10-year rule? Yes, they'll have the 10-year rule. My tax attorney thought there was a reason not to have trusted beneficiary in IRA. I don't want it to sound bad, but I think you need to get another tax attorney because every tax lawyer knows that you can name a trusted beneficiary for an IRA. There's see-through rules. They get the 10-year payout based on the life expectancy of the oldest trust beneficiary. You could Google this yourself and you would find that out. So there's a few things not quite right with that, Pat. Maybe you want to come in and talk to me. Alice, if I get an inheritance, can I put it in an MAPT without worrying about a look back on it? So it's not an actual income, but inheritance? No, because once you get it, it's yours, and there's a 5-year look back. So nothing, even if you disclaimed it, it would still be a 5-year look back. Anonymous. Do I need to file income tax return with any of these trusts? With the revocable trust, uses your social, no tax return. With the irrevocable trust, you have to file what's called an informational return. It's only a one-page return, has a bunch of zeros on it, but it tells the IRS all the income from my irrevocable trust coming to me, I'll pay the tax on my individual return. So this is called an informational return for the irrevocable trust, but you don't have to pay any tax. It's anonymous. Some people say you have to fund the trust depositing money. Well, if you set up a trust, you're going to fund it. The inheritance trusts, we don't fund them. They stand by, so they're not valid until the money goes in. But so what? There's nothing in them. They don't need to be valid. So when they get funded, they spring up. The validity occurs by virtue of the funding. Until then, they don't need to be funded. Richard, why do revocable versus irrevocable? Irrevocable, Richard, to protect assets from long-term care. That's the main difference. So this has been wonderful, a great evening. I enjoy it, as you can tell. And I'm looking forward to meeting all of you by phone, Zoom, and hopefully in person. It'll be very nice. So I'm going to rest there. Wish you all a good evening. Thank you for coming. Thank you for listening. And good night.